For now a year, the General Court Martial had suspended its activities following the Supreme Court ruling in the Attorney General versus Michael Kabazuguluka, which halted its operations on grounds that it had been functioning outside the Constitution and its jurisdiction. The Supreme Court directed the Office of the Attorney General to amend the UPDF Act to align it with the Constitution and clearly defined the court's jurisdictions, among other reforms. Following the amendments to the UPDF Act and the completion of the required legal processes, the General Court Martial has now resumed its work. During today's session, chaired by Brigadier General Richard Tukachungura, alongside other panel members, the court commenced with plea taking for 12 suspects charged with aggravated robbery and the murder of Munyandarazi Geoffrey Juma.
Muhimo Julius, a.k.a. Ernest, Kasule Tony, a.k.a. Anthony, Sabit Ibrahim, a.k.a. Hassan, Bonahe Ronald, Barbara Erbil, Kasima Edwin, and Kasada Alan. All around the 1st of December 2025 at Hilton Garden Inn, Cambodia, Central Division, Kampala City, by force, abducted Munyarazi Geoffrey Jama against his will with the intent that he may be murdered.
Among those charged is Staff Sergeant Kalanzi Jotham, while the remaining 11 suspects were all civilians.
Ordinarily, civilians, not every civilian will be tried in a military court. But for example, if a civilian commits an offense with a soldier, then that is an exceptional circumstances. He can be charged before a military court. And when you are charged is another. So even if you committed the offense in 2023, you have never been arrested, and you are arrested today, you cannot raise it as a defense that you cannot be charged before this court. Because as you can see, the charge sheet is reading case number 1 of 2026. And that person has not been charged before this court.
In separate cases, Major J.B. Habyarimana was charged with 1 count related to interference with the due process of the law, while Kopolo Kauka Bernard pleaded guilty to 1 count of desertion from the army on 12th June 2025.
Criminal case number UPDF for this year, 004 for 2026, dated 12 February 2026. Charge sheet, Uganda versus RA 285615, Private Kauka Bernard, a mere adult of sound mind, aged 27 years, a militant of regular forces of Uganda Defense Forces attached to School of Defense Intelligence and Security. As a reformer, a person subject to military law is hereby charged with statement of offense absent without official leave contrary to section 146, subsection 1 and 2b of the UPDF Act. Caption 30. Particulars of offense: Private Kauka Bernard, who is authority left School of Defense Intelligence and Security, but he did not return to the same unit upon the expiration of the period for which his leave was authorized. However, and understood the charges dated 12 Spring 2026. Charge sheet: Uganda versus RO 12378, Major J.B. Habyarimana, a mere adult of sound mind, aged 45 years, a UPDF senior officer, resident of Sekampolo district, employed at Defense Intelligence and Security Headquarters as a head interrogation under Directorate of Counterterrorism. The person subject to military law is hereby charged with count 1, statement of offense, section 164, subsection 1 and 2d of the UPDF Act, Caption 30. Particulars of offense: Major J.B. Habyarimana on or around the 8th day of July broke the rules of security of prisoners prescribed by the defense forces. Have you ever understood the charge against you? You are accepting or deny the charge?
Brigadier General Richard Tokachungura emphasized that the court is now operating in accordance with the Supreme Court's guidance and the amended law governing its mandate.
This is a reconstituted General Court Martial manned by lawyers who are professional in the field of law. As you saw, two of my colleagues are lawyers. I am a lawyer. We all underwent interviews with the Judicial Service Commission. Chairpersons of the panels, each is qualified to be a High Court judge, and we met those requirements. The other two lawyers may not have those qualifications, but they are also on panels. A High Court judge sits as one person, but with the same qualification like I have. So when you have three lawyers trying one case, I'm very sure that you should expect much more than even you can expect outside in the civilian courts.
Prosecution led by Gifting Nahabo informed court that investigations are still ongoing and requested additional time to conclude the inquiries. All the cases were adjourned to 26th February. For mention, Brigadier General Richard Tokachungura stated that the court is now better prepared than ever before to handle all matters within its jurisdiction, including cases that arose prior to the amendment of the Act.
We are banned. There were several issues arising from the decision of the Supreme Court. One was the constitution of that court at the time. People who were on the court, my role, I was there as a judge advocate of the court, but my role was advisory. And the Chief Justice, then Emeritus, His Lordship Owinudolo, gave guidance in his read judgment that under exceptional circumstances, civilians may be tried in a military court. And any civilian being charged here, we must cross-check and be sure that he falls within the exceptional circumstances under the law, which has been passed by Parliament. So it's not that they are here either by floating the law, but whoever comes here will be in compliance with the law as it has been amended.
He added that unlike other previous system, the court will now handle cases on weekly basis to ensure efficiency.
Under this law, the EPDF Amendment Act, me as the head of the General Court Martial, my panel handles appeals strictly. Appeals are handled by my panel. Then any other cases also like the ones I have handled today, my panel can handle them, but also the other panels can handle both capital and non-capital offenses. But I don't need to be here. As long as it is a panel of three, chairperson, where I have two panels of the same experience, of them will be chairing that panel and it will sit as a court martial. Meaning that another court martial can go even and sit in Moroto, or it can go to Guru. If we have capital offenses in Guru or Moroto, we don't need to bring those suspects. Say they must come, be in Ruzira, be in Makinde, and it will expedite the whole case disposal. Because if an offense is committed, for example, in Moroto, witnesses are in Moroto, in Guru they are there, maybe Mountain Division in Fort Potro. So if a court will go, the way you have been seeing the Court of Appeal goes and on session, maybe 1 week, 2 weeks, it handles cases arising from there. So it is also cost effective. Dispensation of justice is much faster. Instead of saying you will be calling a witness, maybe reaching here, it will be a problem. But once you go on the ground, the jurisdiction where an offense was committed, of course, it's not a field court. It's a court seated in a courtroom, but I believe evidence can easily be collected if it is there. Witnesses will come. Instead of saying you have to bring them from Muchisoro to here, that's why some of the delays in cases disposal.